I'm going to talk briefly about emergency powers and their implications for human rights and the role of judges in regulating all of this. I'm sharing thoughts from a recent writing project, which has been influenced by recent developments in the United States and the fact that we recently marked Holocaust Remembrance Day. I think it's important for human rights advocates, and especially students who might not have as much familiarity with the topic, to think about the role of emergency frameworks and their impact on rights under national constitutions and on internationally recognized human rights. Most of us would agree that there's a need to respond to crises when a natural disaster, pandemic, insurrection, or terrorist acts occur, that we need to be able to respond in a quick and flexible manner. And that may mean making exceptions, suspending certain laws, limiting rights, or changing the structure of governance. And doing that was very easy in the time of monarchs, who could amend or suspend laws with the stroke of their pen. But when states moved to written constitutions and rights, there was a need to find a way to allow for this dynamic and flexible response in those situations. And so the framers of constitutions attempted to accommodate emergency situations by providing a process for suspending the law within the constitutional order, usually upon decree of the executive. The French Constitution from 1799 provides a good early example of this. And essentially what it did is it said that the Constitution could be temporarily suspended by executive decree in the case of armed revolt or disturbance. But note, and I think this is really important for us, that the suspension of the law was not triggered by the existence of these events. It was triggered by the proclamation of their existence by the executive. And so human rights law itself has a similar framework in the derogation regime, and it's triggered in a similar manner by decree of the government. In human rights scholarship, we refer to the deployment of these types of emergency measures as a state of emergency or a state of exception, in which certain laws, including fundamental rights, can be suspended. And at the same time, government powers can be consolidated into the hands of the executive or, in some cases, military authorities. And essentially, the state is confronted by a mortal threat, and it responds by doing things that wouldn't be justifiable in normal times. And again, this seems reasonable and necessary in many ways. But keep in mind that in most cases, the state of exception or the state of emergency is triggered by an executive or legislative proclamation, a political act. And this, of course, raises the possibility that an emergency might be proclaimed or maintained as a pretext for the executive to curtail rights and enjoy these extended powers. In these situations, a nation can claim that it's operating under the law while the protection of the law is essentially placed upon the shelf. Scholars such as Giorgio Agamben point out that the state of exception is the creation of the democratic tradition and not the absolutist. In other words, this is a product of democratic constitutional systems. Adolf Hitler, for example, was legally installed as Germany's chancellor, and Nazi judges would acknowledge that the Third Reich was established through a willed state of exception in which they could still claim legality and legitimacy under the Constitution while perpetrating the atrocities of the Holocaust. One of the problems that's been repeatedly identified is the absence of institutional safeguards to ensure that when emergency powers are used, that they're only used to the extent necessary for self-preservation and for a minimal duration. Often the decision to deploy emergency powers is left to the executive, in some cases, but not always, with a requirement for ratification or an option for override by the legislature. But one concern is that these emergency powers can be deployed to effectively block judicial review of government actions. And this is what the United States attempted to do at Guantanamo Bay. It argued that detainees were beyond the jurisdiction of any American court, meaning that the legality of their detention and the determination of any rights would be left solely in the hands of the executive, and that state continued until the Supreme Court firmly rejected it in 2008. So to turn from domestic systems back to the international human rights system, it's important to note that guarantees of judicial protection in human rights law are largely subject to derogation or suspension, except for those related to fair criminal trials, which means that a state can claim that it's fulfilling its human rights obligations while avoiding any judicial review of its actions if it simply doesn't hold criminal trials. Human rights institutions such as the European Court of Human Rights have tended to be very deferential to states in their determination of emergencies. I want to identify one potential exception that has the possibility to provide a modicum of judicial regulation in these emergency powers. And this is the right to judicial review of detention, Article 9.4 of the ICCPR, which has corollaries in other major human rights instruments. This right has been identified as not subject to derogation or suspension during emergencies by the Inter-American Court and the United Nations Human Rights Committee. The notable exception is the European human rights system, where this right still remains derogable. I think it's important for those of us who work in and care about human rights to be aware of the broad scope of emergency powers in national legal systems and in the human rights system itself, and to think about how we might ensure effective regulation of these emergency powers to avoid their abuse. And in particular, I urge us to think about the role of the judiciary in doing so. I'd argue that making judicial review of detention non-derogable is an important start. So I hope that gives some introduction to this topic, and I look forward to any questions.